Hi, and welcome to the third and final video for our lectures on Module 4. I found it beneficial and necessary for us to include a brief discussion on the Laguna Lake Development Authority, as this uh, topic would have some connection with the discussion on uh, the Pollution Adjudication Board's jurisdiction. All right, especially that the Laguna Lake Development Authority is also vested with power to take cognizance of cases of controversies that involve pollution. However, its delineation of jurisdiction is limited on a specific territory. Okay, because LLDA's jurisdiction is more specialized in terms of territorial jurisdiction than that of the Pollution Adjudication Board. Let me explain. Uh, as a general rule, the Pollution Adjudication Board's jurisdiction is of general application in the whole territory of the Republic of the Philippines. All right, such that when we try to illustrate that uh, the whole territory of the Republic of the Philippines is subject to the jurisdiction of the Pollution Adjudication Board insofar as pollution is concerned. However, okay, this general jurisdiction is subject to special laws that grant special jurisdiction, more specialized jurisdiction on pollution in limited areas. And one such area is this, all right? This area called the Laguna Lake, all right? And in this area, the Laguna Lake Development Authority has jurisdiction to take cognizance of pollution incidents, of pollution cases, all right? Such that while it is general rule that the Pollution Adjudication Board has jurisdiction on pollution, it is qualified it is qualified rather that this general jurisdiction will not apply in cases where the law vests jurisdiction over pollution cases on some other specialized government agency. In this case, insofar as Laguna Lake Development area is concerned, it's the Laguna Lake Development Authority which has jurisdiction. All right. Thus, insofar as the Laguna Lake area, as I said, PAB will have no jurisdiction anymore, even if the incident involves pollution, because the matter or controversy is cognizable now by the Laguna Lake Development Authority. Our basis here, we can find basis here in the pronouncement of the Supreme Court in the case of Laguna Lake Development Authority versus Court of Appeals, decided in 1994, wherein the court, in reconciling the existence of the Laguna Lake Development Authority vis-a-vis the Pollution Adjudication Board, stated that while it is the general rule that adjudication of pollution cases pertains to the Pollution Adjudication Board, it is qualified with an exception that where the special law provides for another forum in specific instances or specific territories, then that special law will have to prevail. No? And because the charter special law provides for a specific jurisdiction insofar as the Laguna Lake area is concerned, and this specific jurisdiction is vested on a more specialized administrative agency called the Laguna Lake Development Authority, no, then it must be construed that LLDA will have jurisdiction even in pollution cases, even over pollution cases rather, in the territorial jurisdiction of the Laguna Lake Development area. All right, uh, and therefore, under such broad grant of power within the Laguna Lake area, LLDA, not the PAB, will have the responsibility to protect the elements of nature within that area, okay, from the effects, the deleterious effects of pollutants emanating from sources of pollution, no, sources of pollution of resources. All right. uh, and again, we reiterate this, that the Supreme Court held that while it is the general rule of the that the Pollution Adjudication Board has jurisdiction over pollution cases, insofar as the Laguna Lake Development area is concerned, it's the LLDA and not the PAB. We note, however, here the discussion in the case of Republic versus Mar Copper Mining Corporation in 2000, decided in 2000, wherein the court said that while that's the pronouncement of the court in Laguna Lake Development Authority, to the effect that as a general rule, PAB has jurisdiction over pollution cases except when special laws provide for another forum. Okay, in which case, if LLDA, I mean, if in the case of the Laguna Lake Development Area, it's the LLDA. It's not the same with mining areas, okay? Because according to the court in this case of Republic versus Mar Copper Mining, the Philippine Mining Act, okay, does not provide for another forum insofar as pollution, adjudication of pollution in mining areas is concerned. According to the court, the Philippine Mining Act does not vest quasi-judicial powers in the mines regional director. It does not vest jurisdiction over pollution cases on the panel of arbitrators in the Mines Adjudication Bureau. There's no such jurisdiction, there's no such grant of jurisdiction over these pollution cases. And so according to the court, while that is true, that special laws may qualify the general jurisdiction of PAB on pollution, in this case of Republic versus Mar Copper Mining Corporation, authority is still vested with the Pollution Adjudication Board because there's no such special law which grants the power to adjudicate on pollution to another forum. Okay. Okay. Now, just a quick run through on the powers and functions of the Laguna Lake Development Authority. Just a quick case study. Okay. Because the LLDA is granted several special powers under its charter, and then the same was expanded by subsequent legislations or subsequent pieces of legislations, such that in the case of Pacific Steam Laundry Incorporated versus LLDA, decided in 2009, the question on whether LLDA has the power to issue cease and desist order arose. No, we have to note that under the charter and under the subsequent laws, the LLDA was not given an express power to issue the cease and desist orders, or and the power to impose fines in accordance with its charter. In this case of Pacific Steam Laundry versus LLDA, the court said the court rather the court, while it conceded that there's no such express power granted under the law, all right, still it upheld the power of LLDA to issue an ex parte cease and desist order and to impose fines for violations subject of that ex parte cease and desist order. According to the Supreme Court here, LLDA is an administrative agency, and an administrative agency will have powers based on express express grant of powers, but also administrative agencies enjoy such powers which are necessarily implied in the existence of its express powers. According to the Supreme Court in this case, LLDA has the power to impose fines, that has the power to issue ex parte cease and desist order in the exercise of its function, not only as a quasi-judicial body but also as a regulatory body with respect to pollution cases in the Laguna Lake region. Such that the court here said that while it's not expressed in the law that the LLDA has the power to issue ex parte cease and desist order, it's not expressed that the LLDA has the power to impose fines. The court here held that these two powers are impliedly necessary or necessarily implied in those express powers being regulatory and quasi-judicial in nature. All right. Now, just to discuss a little bit on how to appeal from the decision of the LLDA. The rules of procedure for LLDA proceedings would state that appeals would have to be resorted to by any party who is not satisfied with the decision or order of the authority within 15 days from receipt thereof. And that filing is done via notice of appeal, all right, appealing the case to the office of the secretary of the DNR or directly to the office of the president, provided that there should be no simultaneous appeals that must be allowed. All right, and the decision or order of the authority shall immediately be executory, notwithstanding the appeal, unless the OSEC of the DNR or the office of the president issues an enjoinment, issues an injunction on against the implementation and enforcement of the decision. Right? And that would be the end of our discussion on it's a very brief discussion on the Laguna Lake Development Authority. And that also ends the first part, actually, of our discussions for this semester in this course. So the next activity that we are going to have, aside from the given written and group activities, would be the midterm examinations as scheduled by our department. So thank you for listening to our video lectures for Module 4. I wish you good luck and I wish you well for your midterm examinations. All right, see you in the midterm examination, on the midterm examination schedule. Thank you and bye-bye.